So thank you, and I guess I'm glad I'm not going last, but I will say that I'm just going to repeat a lot of the things that other people have already said. However, as the lawyer, I am the designated wet blanket. I'm the one that brings the the downer to the party, that reminds people that unfortunately, as lovely as we all want to get along, that doesn't happen. And that's one of the things when we get into integrated project delivery. There's been I challenge you to go out and find a case where an integrated project delivery contract has been litigated in public. We in the legal profession tend to improve things through breaking them. We are kind of the antithesis of construction. We are deconstructionists. We look for things that fail and then figure out how to keep them from failing in the future. Well, integrated project delivery is designed and intended not to fail. And that's where it's a mysterious thing to us. We look at it and go, we're just cavemen lawyers. We don't understand this concept. So we look at it and try and get our heads around it, but staying with in our legal concepts. Oh, I gotta advance it on my own slide here. And it is balking at me advancing my slides. Oh, there we go. All right. The integrated project delivery agreement tends to have a lot of aspirational language, and lean terminology is not necessarily recognized in the legal community. When we see a term like reliable promising, dependable commitments, we get the shakes a little bit because we're not really sure, well, what does that mean? Is it a promise or not? Is it a commitment or not? There are no modifiers to those nouns. So when we're looking at something and drafting something like that integrates some of the lean concepts in aspirational language, we get a little concerned about, okay, what's this going to mean when people start challenging each other? Is there a different definition? And what do I look to help me define what this term means, so that when I'm advising whoever I'm representing, which is another issue in IPD, but when we're trying to inform someone so that they can make an intelligent decision, we have a difficult time knowing where to look to say this is what this means. Because usually we're either looking at statutes, we're looking at case law. And when you talk about, industry standards or the way that contract language develops over time, which, if you look at the AIA language, the A201, and you compare a 1977 A201 to a 2017 A201, you will find substantial differences. Why did those differences happen? Because of disputes and because of issues that have been encountered along the way and disagreements that have created that crucible through which language gets, sometimes we consider it improved, or language gets changed. With IPD, it's really the discussion, the crucible is the relationships of the parties to that project. And you've got to have greater owner involvement. Dave said it, Jack said it, Bob said it, Katie said it. It all comes down to the owner cannot expect a turnkey operation. The owner has to be involved from day one to day last. The owner needs to be involved in the management team. The owner needs to be involved in all of the decisions along the way. Now, in some forms of the contract, the owner is an equal part of the management team. And in other forms, the owner is the final decision maker with advice and counsel from the other members of the management team. So those are the types of things that you start discussing with people. So the contracts tend to have a lot of goal-oriented language, outcome-oriented language. This is what we want. This is the program that we're looking for. Here's the budget, and we want to hit these types of performance metrics, which is kind of, you know, like some of the contracts for a power plant, but you're not typically designing a power plant. So you may have a class building, you may have a hospital facility. So it's got a lot of moving parts and a lot of different metrics that require that type of discussion. And as Dave mentioned, transparency is absolutely critical. If there's an agenda that someone is harboring, that's going to bring everything down. And you know, the trust but verify, going back to the Russian proverb of doye no provyai and the Reagan-Gorbachev days, that is absolutely critical. And for the lawyers working relative to IPD, one of the other questions that we always have is, who is our client? Who are we representing? If I'm representing the owner, I've got to be careful, because I may be telling the owner's looking at it saying, well, I want to be protected. You know, okay, well, I'm not going to be the one protecting you. You have to be the one protecting you. Now you have to give me what your expectations are, and we can put it on paper, and then we can discuss it, and we can reach an agreement as to what's going to happen when. But you know, a lot of times the hard-nosed negotiation, the expectations that an owner typically wants, and that's what, you know, a lawyer is tasked to get, doesn't really apply in the IPD setting because of that concept of risk sharing and risk management. So that is a part of a challenge that we run into as lawyers when we're advising somebody on an IPD agreement. And it doesn't matter if you're the owner, representing the owner, or representing the contractor, representing the designer. One solution that has been used on different projects has been a project counsel, where a lawyer represents the project. If you're trying to avoid costs, that's probably not the best way to do it. But it does make people a little bit more comfortable, some of the lawyers a little bit more comfortable, because then they can say, well, you know, I did what I could to protect you within the confines of this agreement, so that there's no misunderstanding as to whose side are you on. You know, when you're telling me, you know, you're my lawyer and you're telling me I am supposed to waive liability, I am supposed to disclose this information, that I am supposed to be agreeing to share the project proceeds with these other people. So that's where you get that mindset, that behavioral change that's been talked about. And we deal with the concept of IPD as a philosophical construct. And you get the different elements, whether it's the contractual, behavioral, or the catalysts. So in the contract, some of the IPD characteristics with the integrated agreement with everybody joining, that shared risk reward, which is a huge topic of conversation. What does that mean? The liability waivers, that's another one that's like, okay, what does that mean? Which liability, consequential damages or other forms of damages? The fiscal transparency that a lot of times the owners are saying, well, I want that on the contractor and the architect. And then they're turning back, the contractor and the architect are looking at the owner and say, well, I want to see how much money you have available. You know, if I'm going to commit resources to this, I want to make sure that you're in on this and that you have access to the funds in order to pay us. The early involvement of key participants. Now, the interesting thing as the philosophy develops, you don't necessarily need to be an IPD. I mean, you can have design assist and the early involvement of some of the subcontractors on a CM. You can have them in different types of project delivery methods, multiple prime. So there are these philosophy elements that can come into play. But the others are the jointly developed project criteria and collaborative decision making. It's not sometimes when you look at a traditional model, the architect was always the center of the universe. You know, they were the ones that were collecting all of the information, and by and large, were making a lot of the decisions. And sometimes the owner was just confirming those decisions. Here, it's really a team effort, and it's expected to be a team effort. And if somebody's not going to carry their weight, this is when the lawyers come in and say, okay, well, now what am I supposed to do to enforce that? And it becomes less of a legal obligation as almost a moral obligation, because now you've got all of the peer pressure of the other IPD participants leaning on that person saying, you're putting us all at risk by your bad behavior. And there are times where a non-delivering participant will be asked to exit the project and bring somebody else in. Now those, you know, sometimes that's left to the participants without necessarily legal involvement, but that's the type of thing that, you know, lawyers would get involved with. But again, we typically deal with prescriptive language. You must do this, you shall do this, you are prohibited from doing this. We don't do well in enforcing aspirational language. You know, that's part of the problem when you get into this, is our hammer gets covered with a big layer of velvet. So when we drop it on somebody, it doesn't leave as big of a mark. So we need the participants in the IPD project to police themselves. You know, you call in the lawyer to tell somebody, you need to change, you need to behave, you need to do what's required in the contract, and that's fine. But what are you going to do about it? So it's better that you have those conversations at the beginning of the project to establish those rules of the mutual respect and the trust, the willingness to collaborate, the open communication, those conversations, because the other things are just tools. That multi-party agreement, the BIM, the lean design and construction, they're tools that assist with implementing the philosophy of IPD. So when you get into talking about the document, the contract, well, it really has a role, whether it's the AIA documents and which one, you know, because the AIA does have 3 different types of IPD agreements. Then there's the consensus docs, and then there's some other forms. Some of them are proprietary and some of them have been developed by different owners. But really the contract is the agenda for the discussions. What are you going to talk about? How are you going to manage the project? What does a risk sharing look like? What does a profit sharing look like? How are you going to achieve all of these goals? And then it outlines that decision-making process. So that you're trying to figure out, well, I haven't done this before. I don't understand how to make collaborative decisions. Well, describe it. Identify what are the steps you're going to implement. And that's where the forms that are available give you some suggestions and guides. They're not intended to be signed off the shelf. I mean, there is no standard form that that is agreed to and defined among the industry and saying, yeah, that's what it means. So you have to get into those discussions about what are the financial terms, what are the commercial terms, what is a fee, what's profit, what are the costs going to be, what's included, what's excluded, and then what is the dispute resolution process going to be? There are going to be issues that come up. How are you going to resolve them? You have those uncomfortable discussions in the beginning so that when the issues arise, it's not a big surprise anymore. And then this notion of risk, and how do you handle risk and how do you manage it rather than allocate it? So that's where we get into, again, the lawyers trying to figure out, well, what is really changed here? Because they hear about the collaboration and people saying, well, we want to get along, we want to all jointly make decisions, but that's not a substitute for accountability. So just because the team made the decision, there's still some fundamental responsibility relative to some of the decisions and implementing the decisions that are going to remain some level of accountability. So even while you're sharing the risks and other rewards, you're retaining your own responsibility for what you do. You know, you remain the master of your own domain, in a manner of speaking. But one of the critical players that tends to get ignored is the insurance. Because when they start talking about these concepts of liability waivers, and risk allocation and risk management, insurance is compensated risk management. You buy an insurance policy for the project, whether it's an OSIP or a RAP or some other product that they are developing, some that are specifically for IPD projects that address those kinds of risks that really, no one individually may need to bear that risk, but you've compensated an insurance carrier to cover that risk. But you need to have the insurance broker at the table during the discussions relative to how are you going to do this project. And then finally, the last thing you need to do is test the contract. It's like you've got it, you've negotiated it, you've worked it to the point where you think that you're comfortable. Now start throwing hypotheticals. What happens if? Who's going to do what if something happens? And it's not so much the scenarios you come up with, whether they're outrageous or absurd, or you look at it and say, what happens if there's another pandemic? What are we going to do? Who's going to do what? What actions are we going to take, and who's responsible for what? Does the contract adequately address that? That's what you need to start testing to see if the document that you have worked on and walked through and developed does address the issues that you really need it to. So those are the things from our perspective. Like I said, we tend to see the dark clouds behind every silver lining, but that's where we go.
Thank you very much, John. I appreciate it. Again, we're here to encourage everyone on the IPD methodology and the delivery method. But again, we have to look at the challenges and understand those challenges. And that's why we have John and Reed to kind of give us a better perspective of how to do that from their success stories that they've been applying IPD. So Reed.